All right, good afternoon, everyone. My name is Matthew Orlansky. I'm a partner here at the law firm of Cass and Peters. We specialize in workers' compensation law. We've been representing injured workers here in New York for over 40 years now. Personally, I've been in the field of workers' compensation for about 15 years now, representing injured workers. And we're here to take any questions, comments you have about the law. I'll try to talk a little bit about workers' compensation, what it is, who's entitled to it, how you can claim it, and what you can expect if you are hurt on the job here in New York. So just a little bit of a background of the workers' compensation law in New York. It started about 100 years ago with the Triangle Shirtwaist Fire, where a bunch of workers who were trapped in a factory were unfortunately killed while they were working. And that led to a bunch of reforms with the New York statute, which gave birth to the workers' compensation law as we have it today. Workers' compensation claim does not work like a traditional lawsuit. So instead of filing a complaint, what you do is you file a form called a C3. And it's more akin to a claim for insurance when your car is damaged than it is to an actual lawsuit. To be eligible for workers' compensation in New York, you have to be considered an employee, which is a legal distinction. And if you are considered an employee and have an employer, and you are hurt while on the job, then you are entitled to two different things. You're entitled to payment for any lost time that you have as a result of that injury. Wage loss can come in many forms. We'll talk about that a little bit. And you're also entitled to medical treatment for the injuries you sustained in that work-related accident or injury. Now, speaking of injuries, there are many different types of ways that you can be hurt on the job. The most common that we see is a specific accident, like somebody, slipping and falling, banging their knee on a table. It can be anything like that. But when there is a specific accident like that, there's two things you should be aware of when making a workers' compensation claim. First and foremost, you must notify your employer within 30 days of that accident. So that can be done either orally or in writing. Writing is preferred because if there's ever an issue with that, that's an easy way to prove that your employer had sufficient notice of the accident. But doing it orally is fine as well. Once your employer is notified of that injury, then it's your burden to file the workers' compensation claim with that C3 form that I discussed earlier. If you call our offices, we will assist you in filling out that form and making sure it's complete and completely accurate, because that's the form that's going to bring about your workers' compensation claim. Now, this is very important. You have 2 years from the date of your accident to file that workers' compensation claim form. If the accident happened over 2 years ago and you have not filed a claim, there is a strong chance that claim will be disallowed. Not all the time, but most of the time. So it's very, very important that you do file that claim form and notify your employer within those 30 days. Now, the other type of injury we often see as occurring at work is something called an occupational disease. Now, that's an injury which may not come about from a specific accident, but by doing something physical over time, which can lead to a degenerative injury. Some of the most common types of injuries we see with this are carpal tunnel from typing too much, back strains from having to lift heavy materials or packages or anything like that. And particularly with construction workers, we can see these types of degenerative injuries occurring all over the body. Now, with these types of claims, it's a little bit different. Because they're not always, you don't always notice them right away. you do have 2 years from the date you knew or should have known that the injury was work-related to file these claims. So even though you might have started feeling the pain more than 2 years ago, if you had no idea that this was work-related, then you can still have a timely claim as long as you do it within 2 years of you knowing that it was work-related. Now it looks like we've received our first question of the day here. It's from Stan, and he's asking, and this looks like this goes to the notice issue, what if I got hurt at work and I didn't want to say anything because I didn't want to get let go, and then they let me go? I can prove I went to the hospital. If I went to the hospital, can I still get workers' comp? So to answer the first part of that question, as I just said, it's very important that you notify your employer of that injury within 30 days of the accident. Claims can be disallowed purely on that basis if your employer did not have sufficient notice within those 30 days. Now, as far as being afraid that you're going to be let go if you tell your employer that you were hurt at work, you do not have to be afraid of that. In New York, it is illegal for employers to discriminate against you in any way, shape, or form because you were claiming workers' compensation or a work-related injury. Now, every employer in New York is required to maintain workers' compensation insurance if they have even just one employee. It is the law here, and any employer who is found to have violated that, particularly when they have a workers' compensation claim filed against them, is subject to massive fines and penalties. So it's important to note that when you're filing a workers' compensation claim, you're not suing your employer. You're not claiming that your employer directly has to pay you anything. It's their insurance company, insurance which they are required to pay for, whether you got hurt or not, that is going to be liable for your benefits. So do not fear telling anything to your employer about the injury. It's very important you do this right away. It could affect your right to have that compensation claim go forward. And I have seen, unfortunately, many claims get disallowed because somebody withheld the fact that they were injured on the job from their employer for too long. So definitely tell your employer no matter what. Even if you think it's just a minor thing, you never know if down the line that can develop into a more serious issue. So definitely tell your employer as soon as you get hurt at work. Looks like we have a second question here from Benjamin, who is a home health aide, and he said he slipped and fell. Is he eligible for workers' compensation? Well, if you slipped and fell while you were in the course of working as a home health aide, usually you see them at patients' homes. Yes, you absolutely are entitled to workers' compensation. Even if you're part-time. All we have to show is that you were employed by someone. And just speaking a little bit about that, to be considered an employee here in New York, you have to show that somebody has direct control over the activities you do at work. So if somebody sets your hours, if somebody tells you exactly what you have to do, and most important of all, if somebody has the right to fire you if you don't do that, generally you are considered an employee here in the state of New York. Now, there are certain situations where with construction workers where it becomes a little more iffy on that. Particularly we see this with a lot of undocumented workers, but with construction type injuries, the workers' compensation law is even more ironclad than that. And generally speaking, if you are working construction in the state of New York, you are considered to be an employee. Now, going back to that slip and fall, again, it's just important, really important, that you notify a supervisor from your employer about that injury within 30 days, and that you then file your workers' compensation claim form within 60 days. Again, excuse me. it's very important, even if you don't think it's something serious, to file that claim. As long as that claim form is filed, even if you let the case sit idle, if God forbid something does happen to you down the line, you will have the full benefits and rights of workers' compensation going forward. And again, if you have any questions or any difficulties with filing that claim form, please feel free to give us a call here at Cass and Peters. We can assist you with filing that claim, with finding a workers' compensation doctor, with helping you every step of the way. All right. So now that we know that who's eligible for workers' compensation, and we know what you have to do to make sure that you don't run afoul of any statute of limitations or time limitations, what's the next step? Well, if it's an emergency, get emergency treatment immediately. Call 911. Go to the hospital. Go to the emergency room. Even if you don't have insurance, when your workers' compensation claim gets established, the insurance carrier on that case will be responsible for paying for any hospital bills or medical bills you incur after that. If it's not something super serious that requires immediate attention, I would still urge you to see a doctor as soon as you possibly can. And it's very important, whether at the hospital or at your own doctor, that you specifically tell them that this was a work-related injury. Many times with contested workers' compensation cases, the judges are very quick to point out whether or not there's what we call contemporaneous medical evidence. So if we have a medical report from a doctor saying that you got hurt while you were at work and diagnosing injuries from that accident, more often than not, the judge is going to believe that those injuries occurred from that accident, particularly when we see it close in time to the actual accident. While it is not a specific requirement to see your doctor within any period of time, as long as you've specified the notice and filing requirements for workers' compensation. Seeing a doctor right away can help if there's any other issues that come up with the claim, whether your boss is trying to claim that, this accident never happened, what are you talking about? So see a doctor as soon as you can. All right, looks like we have another question from Cassidy. I drive for Uber full-time, but only have personal car insurance. Would I be still eligible for workers' compensation if I have an accident? So the answer to that is yes. Now, while you might think, based on what I just said several minutes ago about who is eligible for workers' comp in New York, and what an independent contractor is, that Uber drivers would be considered independent contractors. They're driving their own personal car. They don't have anybody telling them, who or where or when to pick somebody up. They can accept and reject hails from the app as they see fit. There has been some recent legislation here in New York that has protected Uber, Lyft, and other ride-sharing drivers and saying that they are considered to be employees. Now, with these ride-sharing apps, there are still a few requirements for it to be an eligible workers' compensation claim. Number one, you can be in the process of a ride, meaning you have picked up a passenger or you have accepted a hail and you're on your way to pick up that passenger. Excuse me. If either of those criteria have been met, then the accident is considered within the course of your employment. Now, as long as you have the app on and you're showing that you are willing to take hails as a driver, that would also be considered to be within the course of your employment. If you were going out for the day, Uber driving, but you had the app turned off, or you just dropped off your last passenger and you were on your way home, and again, it's important that you weren't looking for those hails, then those claims will usually be denied. You can still pursue no-fault injury for those claims, however, even if the workers' compensation is denied. So going back to occupational injuries, once again, Those are injuries that can occur due to that are more degenerative, that can occur over time due to the physical nature of your job over time. And as I said, those have to be filed within 2 years of the date that you knew or should have known about that injury. So if you go to, let's say, you're a office worker who is required to type on a computer for 7-8 hours a day, you start to notice some numbness and tingling in your hands and wrists, and you go to the doctor, and the doctor asks you, when did you notice this starting? And you say, well, I type a lot at work, and this is when I noticed it. And the doctor says, hey, I think this might be related to that. That's when you're on cue, that your time frame to, or when the clock starts running, when you have to file that claim. Again, if you can't tell, my philosophy on this is protect yourself. Even if it's not something you think is serious, file that claim. Tell your employer about it. There is no bad that can come from it. There's only bad that can come if you fail to do that. And with an occupational injury, it's also important that when you do talk to the doctor, you do explain everything you were required to do at work, which might have led to that injury. Be as specific as you can. Tell the doctor about how many days, how many hours you work, how many hours a day you're doing certain activities at work, what you're doing at work that may be physical that leads to those activities. The more the doctor can put into those reports, the better off we are. Because those aren't as clear-cut as specific accidents, insurance companies will usually be a lot quicker to deny those claims. So make sure that you tell your doctors all about everything that you're doing at work that could lead to those. Okay, looks like we have another question from Javier. I'm a trucker and I live in New Jersey. What if something happened to me in another state or I had an accident and I hurt my back? Okay, that's actually a very good question, and something I did want to discuss is who is eligible for workers' compensation benefits in New York. Now, every state has their own separate workers' compensation system. Here in New York, we do happen to have one of the more employee-friendly systems. So if you can file your claim in New York, if you have an accident, which might be subject to a couple of different states, New York is usually a safe bet to file your claim because, as I said, it's very employee-friendly. Now, for an accident to be eligible for New York workers' compensation, your employer had to be doing some sort of business in New York. Now, this is a very broad thing. It's what we call, in legalese, we call it subject matter jurisdiction. Now, typically with, for example, like Javier, a truck driver, you may be driving through many different states. Your base may be located in a completely different state than New York. You yourself may live in a different state than New York. But if your trucking route takes you through New York and you sustain that accident while you are in the state of New York, then you are eligible for workers' comp here in New York. If you live in New Jersey and you come into New York for work every day and you get hurt while you're at work, it's going to be a New York claim. Basically, your employer is required to have workers' compensation insurance here in New York if any part of the business that they do is expected to be in New York. Now, very often we see claims for flight attendants who get hurt while they are flying cross-country. But as long as they are based out of an airport here in New York, you are going to be eligible for New York workers' compensation. Now, one exception to this would be is that if you live in New York, but you work in another state that only does business in that other state, let's say you live in Manhattan, but you go into an office in New Jersey every day for work and you get hurt there, and that company only has an office in New Jersey, then chances are you're going to have to file that claim there. So just living in New York and working in another state usually doesn't give rise to subject matter jurisdiction here in New York, but there are a lot of exceptions to that. So if you think you might be eligible for New York workers' compensation in any way, shape, or form, please call us. We can review your claim. The facts of every case are different. So we'd be happy to help you out. And even if we can't help you here in New York, we work with a lot of other lawyers in the area who certainly will be able to help you with another state's compensation. All right, we have time for a few more questions. So it looks like I have a question here from Gloria. She says, I'm a secretary. I know about my carpal tunnel syndrome, but what about my back? I'm in pain every day. I can't sit for 8 hours in front of the computer. Is there something you can do? And the answer to that is yes. The occupational injuries don't only have to be carpal tunnel syndrome. They can be anything that's considered degenerative. As I said, back strains are a common degenerative injury, not just for construction workers or physically active people, but people who do have to sit in a stationary position for many hours of the day. The important thing is that you need to talk to your doctor, and your doctor needs to believe that there was some link between what you were doing at work and that caused that injury. And again, it's very important that the doctor spell that out in their report, because once we file that claim, we will need that to proceed with the claim. And that actually goes for specific accidents as well. Once you've filed your claim and everything else is okay, we still need what's called, a little more legally, is prima facie medical evidence before we can proceed with that claim. What that is in layman's terms, it's a report from your doctor that basically says that the injuries you sustained were related to that accident. Again, there is no specific time frame for us to get this report in. If you've told your employer in a timely fashion and you filed your claim in a timely fashion, but more often than not, the sooner you can do that or get that report from your doctor, the better. Most of the time where I have a medical report from the date of the accident, within a week of the accident, describing injuries related from the accident, unless there's some other crazy extenuating circumstance, we're going to get that case established for workers' comp. Okay, looks like I have a last question here. Let's see. It's also from Javier. Do you have to be a citizen to get workers' compensation? That is a good question. I touched on that, I think, a little bit before. But the answer is no. You do not have to be a United States citizen to be eligible for workers' compensation. All you have to do is be considered to be an employee here in the state of New York. I will tell you, I know I have dealt with many clients who are here in this country. They may not necessarily be here legally. They may just be on a visa or something like that, and they're afraid if they file a workers' compensation form, it's going to alert other agencies to their presence here in this country. And I can safely say that is not the case. I have never run into a workers' compensation claim with someone who is undocumented where it does result in them being deported or anything like that. The workers' compensation system here in New York keeps that information to itself. Any work-related claim you make will not have you subject to any immigration claim. And as long as you're working, as you're considered to be an employee here in the state of New York, you're eligible for it. It doesn't matter where you're from, where you're a citizen. If you're working in New York, if you're injured while you're here working in New York, you can get workers' compensation. As I've had a little bit of time here to explain some of the basics to you, but while it is very simple to file a claim, the workers' compensation process can unfortunately be a long and complicated process. And that's sort of where we come in. I'd advise you, even if you don't think an attorney is necessary, that you speak to an attorney about your workers' compensation claim. Here at Cass and Peters, we offer free consultations for anyone who has any questions about workers' compensation. Whether you think you have a claim, whether you already have a claim open, I'm happy to talk to you. I'm happy to take to give you information about what your rights are, what you can do. And the best ways to contact us are by phone, 212-349-3420, or you can look us up on the web. Our website is www.cassandpeters.com. That's all spelled out, CASSANDPETERS. Please follow us on Facebook if you're watching this today. If you're enjoying this, we'll try to get some more live Q&A sessions like this coming up in the future. And it's been a pleasure. Hope to hear from you guys soon. Thank you.